Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. And in this video, I want to talk to you about Miranda warnings and a lot of misconceptions that we hear, a lot of misconceptions that potential clients of the firm make, a lot of clients that we currently represent still ask, hey, I wasn't read my Miranda rights. How come you can't get the whole case dismissed? Or I wasn't read my Miranda rights. Can't we get a better deal? And there's a couple of misconceptions about that. And I want to use this video to sort of break it down and talk about what really matters and what doesn't matter when we're dealing with Miranda warnings. Now, a lot of times, you see on TV back in the day, cops or on movies or television shows, anytime someone gets arrested, they get read their Miranda rights. First misconception, it is not mandatory that law enforcement have to read you your Miranda rights. Okay, it's not required as a blanket rule whenever you're arrested. So just because it wasn't done doesn't mean, unfortunately, that you're not automatically going to beat the case. Your attorney's not going to be able to get the case thrown out for that reason alone. Where it really matters, and this is the second misconception, where it really matters is when you are in custody and when you are actually being interrogated. And, being in custody doesn't mean you get a call from a detective and you're on the phone. Being in custody doesn't mean you have a casual encounter with a detective or law enforcement on the street. Being in custody means, one, either you're under arrest, or two, you're not free to leave. Okay? So, that's a key component. A lot of times, I was being questioned. How come I wasn't read my rights? It's like, because you were 3,000 miles away on the phone. Or you were on Microsoft Teams in the comfort of your car, your office. So it's not required. The second component, once it's determined that you were in fact in custody, was that you are actually being interrogated. So you could be in custody and you initiate a conversation with law enforcement, you start blabbing to the cops. That's not being interrogated. Being interrogated is when you're actually asked questions intended to elicit a response that could be incriminating. So if they're just like, hey, how's it going today? And you start blabbing about what you're accused of doing or giving some bogus alibi or talking about a case that you shouldn't be talking about, courts are going to find very easily you have not been interrogated, even if you were in custody. And then the other issue and the other misconception about Miranda is, even if it wasn't done or it should have been done, the whole case doesn't go away. What the real remedy would be is that any statements you made from the point that the rights were supposed to be read to you, any statements afterwards would be kept out or suppressed. Meaning the prosecution, the government couldn't use them against you in many situations. There are a few exceptions. But in many situations, they couldn't use it against you. But that doesn't mean the whole case goes away. Sometimes clients and sometimes people under investigation will actually say things that, although we wish you never say anything at all and politely decline all questioning, sometimes what you say actually may give the seeds to an actual defense. So you don't want to suppress certain statements once they already come in. And other times you're able to suppress statements as a violation of Miranda. Hey, my client was in custody, my client was interrogated, they weren't read their rights, and I want to keep out where he said this or where she said that. Well, that's great, and that could strengthen your position. It could make you reassess whether or not you have a better case for trial. It can put you in a better position to negotiate a more favorable outcome with the prosecutor, with the court, if that's in your best interest. But it doesn't necessarily mean the case goes away. It doesn't mean it's a slam dunk that you're guaranteed to get a better item or a better outcome of what we're trying to accomplish for you. So a couple of things to keep in mind when talking about Miranda issues. Are you in custody? What the law says is custody. Are you being interrogated as to what the law says is being interrogated? And what statements are you actually trying to keep out? It's not going to make the whole case go away, but it is important. It's an important discussion that you should have with your attorney. It's an important thing to keep in mind. But on the front end of it, before we even get there, the best thing you can do, remember, keep your mouth closed. Don't confirm you're on the planet at the time you're being questioned. I want to talk to you about this. I politely decline to answer any questions. Please speak to my lawyer. All you need to say, and you don't even have to worry about, do you have a Miranda issue, or does your attorney have to fight to suppress a statement or keep a statement out of evidence? Why? Because you kept your mouth closed to begin with. Hope this video has been helpful. If you have any questions about a Miranda issue or any criminal case, particularly in San Diego County, you can always reach out to my firm at 619-295-3555.